number 14, the people of the state of New York versus Angelo Burgos. We'll wait a moment, counsel, before you start. We'll allow your colleague to leave the courtroom.
Thank you, Your Honor.
Thank you.
You're welcome. Counsel?
Wayne Gosnell for Appellant Angelo Burgos. I'd like to reserve 3 minutes for rebuttal time.
You may, sir.
Thank you, Your Honor. May it please the court. Throughout his career, Andres Aranda neglected vulnerable clients, lied to courts, and lied to disciplinary bodies when he wasn't simply ignoring them. 10 weeks before appellant's trial, Aranda's pervasive and lengthy history of serious misconduct led the Second Circuit to suspend him for reasons that bore upon his qualification, competence, and moral character. After considering Aranda's serious misconduct, it concluded there was little assurance that Aranda could conform his conduct to expected professional norms.
So, counsel, I'm on the screen. Hello.
Yes, Your Honor.
Good afternoon, yes. So I don't think there's a dispute about the content and the intent of the Second Circuit's determination and discipline. So the question is whether, as I view it, the question is whether or not, since during the trial, the trial counsel was still admitted in New York, whether that, as you argue in the first instance, that's now a constructive suspension, he's per se unable to actually represent him. If you could address that, because he is still admitted in New York during the trial.
His license is on the wall, yes, that is true. But the defect in his character and his qualifications and his competency existed and had been adjudicated by the Second Circuit, which is different from...
But it has no application until the appellate division renders a decision, right? The grievance committee. Until that moment, he is still licensed to practice in New York.
Well, there are two responses to that. First, the first department, when they imposed reciprocal discipline, they imposed that reciprocal discipline for the exact same serious and substantive reasons that the Second Circuit did. And they also made a considered decision about when the effective date of that reciprocal discipline would take effect.
But, Counselor, they made that determination after the attorney was afforded due process.
Well, the attorney had been afforded due process on multiple occasions. First, he had been afforded due process by the Second Circuit, and there had been an actual adjudication.
But he is entitled to due process in New York, correct?
He is also entitled to due process, but if you look at the disciplinary rules and if you look at where the disciplinary rules flow from, which is from a case that's more than a century old by the Supreme Court, Selling versus Radford, where the Supreme Court talks about when there is a defect in an attorney's personal and professional conduct, wherever committed, that operates everywhere and must furnish adequate reason in every jurisdiction for taking away the right to continue to be a lawyer.
So, counsel, what would this attorney do during this interim? It may take the first department, busy department, it may take them a while to adjudicate, so they can't practice.
That's not exactly what would happen. In terms of, for criminal cases, because you have a constitutional right as a criminal defendant, that in that instance, you cannot be counsel under the meaning of the Sixth Amendment and the New York State Constitution.
So they could take no criminal cases, even if later they're exonerated and there turns out to be some procedural defect, whatever it is, they say, no, we're not suspending you for that period as long as it takes them to adjudicate that grievance, that allegation. This attorney cannot practice criminal law in the state of New York.
Well, I think the facts that you're sort of describing them are different than the case we have here, because what we have here, and going back to the prior question, there was additional due process given the attorney, where he was then adjudicated by the first department as being suspended, but the date of the suspension, the effective date of the suspension,
But you're not
was
going to
back
know
to May
that.
15th.
The attorney's not going to know that at the time. So what I'm asking about is, before that happens, that may take a while, that attorney cannot practice on the fear that they may impose discipline, and they may impose discipline non-proton. They may do it effective earlier. So you're, I think, saying that as a matter of ethics, that attorney is unable to practice criminal law in the state of New York until the appellate division determines what sanction and whether it's going to be retroactive.
Well, in the instance that you're describing, where there has not, where we're putting aside what the First Department or what an appellate division does, the obligation on the attorney is to inform his client.
That's a different issue. That's your second issue, I think.
It is, but the two of them are related, because what we're dealing with under the facts of this case for the right to counsel per se is that you have a decision by an appellate division imposing reciprocal discipline that relates back to a time that was before the trial.
You're not going to know that, which is
Correct.
my concern here. You're not going to know that at the time. So you're going to have to, in an excess of caution on the potential that they're going to do this, suspend your practice pending imposition of the discipline.
And to Judge Garcia's point, perhaps the First Department decides it's not a disciplinable offense. Where would the due process be?
Well, first off, the due process that is actually at issue here and the constitutional right, the constitutional obligations relate solely to Mr. Burgos, not to Mr. Aranda. But to your point, Your Honor, the fact of the matter is that what could have happened here, what should have happened here, is that Mr. Aranda should have made a disclosure to his client and to the court, because
Counsel,
Where is that obligation?
that obligation flows from the Constitution and it flows from the ethics rules.
but it doesn't flow from the Second Circuit's decision, because the Second Circuit specified who needed to be notified of their suspension, and your client was not included in that group of people, was he?
He was not, Your Honor. And in fact, but the Second Circuit, when they are imposing discipline, their concern and their obligation is to impose discipline upon the attorney. They are not concerned with, and shouldn't be, and it wasn't before them, about what constitutional rights others may have who may be represented by Mr. Aranda.
I understand that you are concerned with your client's rights, as you should be, but I think what you're hearing from the bench is that there's a balancing. Mr. Aranda had some due process rights here, too. And it seems as if we're testing the limits of what those rights are by, say, suggesting that he needs to withdraw from all criminal representations while he still has a valid New York license because he's been subject to discipline in another jurisdiction.
Well, but that gets into, and respectfully, that gets into the right to counsel of choice issue, that he has an obligation to inform his client. What he did here by hiding the fact that he had been suspended from his client is he was the one who made the decision about who Mr. Burgos would have represented.
So counsel, I'm on the screen. So if I'm understanding this part of your argument, just to clarify, unlike the first part of your argument, which is right, per se, he cannot represent him, you have to stop the process, and a new attorney is either retained or assigned, period. As I understand this argument is the attorney had a duty to disclose this disciplinary action because there might be reciprocal action and he might be then suspended in New York State, so that the defendant could decide whether or not to move forward. I just want to be clear. With this lawyer, is that the argument?
Yes. So
I'm not saying it's per se. The defendant could choose with this knowledge to proceed with this person as his lawyer. Is that your argument?
I believe that what we've talked about in our brief and what I'm saying here is that the first thing that needs to happen is Mr. Aranda needs to tell his client, and then the client needs to make an informed decision, a knowing and intelligent and voluntary decision about whether to continue with Mr. Aranda as his attorney, which is done in nearly every other constitutional
Let's say we agreed with you. Did the lawyer have to disclose to the court, which I thought was your position? And if so, does that mean that regardless of what the defendant would do, if the court decides that this lawyer simply cannot proceed in the case, then defendant loses his right to choice if he wanted to proceed with this lawyer?
Well, it wouldn't be that he loses his right to counsel of choice. The right to counsel of choice has always been viewed by this court and other courts as a qualified right. So, for example, in this particular instance, because of the fact that no one knows when the First Department is going to impose reciprocal discipline, it could happen on the first day of trial.
You said, the truth of the matter is
no one knows that the First Department or any appellate division will actually impose reciprocal discipline until they do, or if they don't.
Respectfully, I don't think that's actually true in this case, because you had, in this case, the only defenses.
No, Counselor, you, with respect to reciprocal discipline, are you saying that the appellate division must impose reciprocal discipline, or do they have the right to make that decision for themselves after their process is completed?
Well, there's two pieces of an answer here. Is first, the appellate division has to follow the disciplinary rules about
Correct.
what are defenses. And so the only defenses that are available to a person who has been disciplined by a foreign jurisdiction are that they didn't receive due process there, that the evidence was insufficient, or that the conduct that was being disciplined is not disciplinable in New York.
And New
There was
York
no
also,
question that.
there's also mitigation that can be offered to determine what actual discipline is imposed.
Yes, but what we're dealing with here on the per se argument is that it doesn't matter what could have happened or what may have happened. What actually happened is the fact that the First Department suspended him and they made its effect
So your rule
retroactive.
is if a foreign jurisdiction disciplines an attorney, a criminal attorney, he cannot, as it was stated earlier by one of my colleagues, he can't practice criminal law.
Well, so I think what you need to look at is, first off, is what's the suspension for? If it's a serious and substantive suspension as opposed to a technical
Who
suspension.
determines that?
Well, this court in the Kaiser case, this court cited to a lower court case that sort of sets out what that is, which is the Chen Min Fu case, where if you have a technical violation such as failure to pay bar dues or things like that, it's not a situation where you need to reapply to the bar to then be allowed to practice. You pay your fine, you pay your dues or whatever it is, you update your address, and you're back to practicing law. When you have a serious and substantive suspension, that's a suspension that goes directly to the core of what it means to be a lawyer, that you don't have the competence to be a lawyer or the qualifications or the moral character. And in order to have that license back, you have to go back through essentially the admissions process and be adjudicated by that body as
Counsel,
now
I'm
being-
sorry. Counsel, if I can just interrupt you on this analysis of Kaiser. It does strike me that there is a difference between saying, we're going to look at the nature of the suspension and make a decision what its impact may have, and this case where, and in Kaiser where that jurisdiction where there's the temporary suspension is the only jurisdiction in which the person is barred. Here, this individual is actually barred in New York State. So regardless of the way one identifies the Second Circuit's discipline, the fact of the matter is the counsel during the trial was indeed still barred in New York State. He had not yet been disciplined. So I understand what you're trying to do with Kaiser, but it doesn't seem to me to work.
But Your Honor, if you're going to read every word and give effect to every word of the First Department's suspension of Andres Aranda, you have to give effect to the fact that they made the suspension effective nunc pro tunc. They made the suspension effective as of May of 2015, which is 10 weeks prior to Mr. Aranda representing appellant at trial.
But
So
nobody knew that during the trial. That had not happened during the pendency of the trial. So, you just proposed a process with a hearing to determine the nature of the violation, but none of that had happened, at least as far as the First Department was concerned, until I think it was a week or two after the trial had concluded, right?
yes, but that goes to the right to counsel of choice issue of whether there should be a hearing, whether or not Mr. Burgos should have been informed of those facts so that he could make an informed decision.
One last thing.
Yes.
It seems like your 2 points are somewhat in tension, because let's say there's a disclosure, full disclosure to the client, and the client's, and both your rules are true. Both points you want to make are we accept. Client says, you know what, you've gotten me great deals, you're going to get me a great deal here, I'm confident, I want you. and then, say, you can't have me because I can't practice criminal law in this state, because I might get suspended nunc-pro-tunc. So which one do you want? Do you want a per se bar where the client can't choose and you can't practice? Or do you want a full and fair disclosure of the facts and circumstances and the client has the right to choose? Because I fear the next case then would be, I wanted that lawyer, he was barred in New York, he hadn't been suspended, but you wouldn't let me have him.
Well, I think that Your Honors can resolve this case under the per se rule, because the specific facts of this case, you have an adjudication by the First Department that was made retroactive to a date that preceded the trial. Just as if at that moment in time, Mr. Aranda had not been admitted, had never been admitted, just like in Felder or some other cases of this court, or the Novak case, where the defect, the adjudication occurred before and was given
Counsel,
effect before.
What about the fact that, quite frankly, applying it nunc-pro-tunc, the appellate division is taking into consideration mitigation, whether they want the time to count or add to that which was originally imposed by the other jurisdiction. So in other words, as opposed to saying, I'm going to suspend you 18 months from the date of this order, they're simply giving him credit for time that he was suspended in the other jurisdiction.
Well, in doing that, again, you would have to add words and subtract words from the First Department decision. The First Department decision didn't say, we'll run the time in which we're counting for the 18 months back there. What it said was, the suspension is nunc-pro-tunc
So the
to May of 2015.
suspension in your mind is not just a timing back, it's a substantive suspension during that period, correct?
Well, yes, because even if, under this court's prior jurisprudence, if it had been a technical violation, that wouldn't qualify. But here you have a serious and substantive violation.
So the rule you want then, if I, the per se rule, let's just stick with that.
Yes.
That you want is for what you're calling a substantive violation. If a foreign jurisdiction has suspended someone for practice for that reason, representation of a criminal defendant in New York State by that person is ineffective per se. Is that the rule you want?
No, it has nothing to do with ineffective assistance of counsel, Your Honor.
Well, then why does the conviction get reversed?
The conviction gets reversed because he was without counsel within the meanings of the Constitution.
Okay, well, all right.
Fine.
So that it's a reversal in that circumstance. Then I don't
is.
have Judge Garcia's concern that that guy's not going to be able to make a whole lot of money. If I were a criminal defendant, I would look at the foreign jurisdiction suspension and hire somebody, because if I'm acquitted, double jeopardy prevents my reconviction, and if I'm found guilty, I get a reversal because I had no counsel.
Well, this court's jurisprudence is also, it has not resolved the question of what occurs if, for example, in Felder or other cases, what occurs if you're represented by someone who you are aware of and you're sort of setting a trap for the courts to set a trap for a deprivation of counsel issue. And I think that this court has dealt with those issues in the context of conflict of interest cases, where you've talked about the fact that, you know, right before trial, you can't sort of put the trial court in a position where either choice that they go with, there's going to be an appeal. The trial courts are given great discretion in those instances. And I think in this instance, you would have, first off, you would have great discretion to deny that if that were the case. But that's not this case.
What you really want is an ethical rule, I think, requiring disclosure. That sounds like what you want.
I certainly think that that would be helpful, but the rule, the obligation flows from the Constitution. If you look at the ethics rules when it comes to conflict of interests, those are there so that the client is informed of it, and to avoid issues of unwaived conflicts of interest, which don't have any, well, they impact the ethical rules, but they're a constitutional violation for the defendant. And so what the court has tried to do, and what the appellate divisions have tried to do with the ethics rules, is to try to avoid situations where there is an unwaived conflict in which the standard is much lower for a reversal. If somebody discloses it, and then the court has a hearing and the issue is waived, and it was a waivable issue, then there would be no issue on appeal, no reversible issue on appeal with respect to that. But respectfully, if a court was faced with these facts, the language of the Second Circuit opinion and Mr. Burgos saying, which would be contrary to the actual evidence here, Mr. Burgos saying, I want him to be my attorney, I don't think any judge, any trial judge would be exercising appropriate discretion to allow Mr. Aranda to do that when they have no idea when discipline is going to be imposed, but everybody knows it's coming. It could happen before the verdict, it could happen in the middle of jury selection.
Counsel, that's not necessarily true. The First Department might say, we're not going to discipline him. So then what?
Well, in that instance, that would be like the conflict cases that we cite to, where if the conflict never actually arises during trial, so long as the court, the trial court in that instance, looks at the totality of the circumstances and makes a reasoned decision and doesn't just make an arbitrary decision, that decision by the court will be upheld. Because again, the right to counsel of choice is a qualified right. You don't get to, demand a new attorney the night before trial just to delay the trial. You don't get to demand conflicted counsel. And the courts trial courts regularly make these decisions in
So
determining how
counsel,
to do that.
counsel, I'm on the screen. That'll be my last question. It sounds to me like let's say we adopt, in terms of your second argument, this rule that it's a rule of disclosure. I'm not sure about whether or not it's the Constitution. I know you argued Professional Rule 1.4, but in any event, let's say we agreed with that. Disclosure to the client, but also disclosure to the court. It seems to me, based on what you're saying now, that the discipline could come at any time. It might throw the entire criminal proceedings into chaos as a consequence. That this would, in effect, encourage, incentivize trial judges to remove counsel, play it on the safe side. Why am I going to move forward and then this person's going to get disciplined and we're going to be back perhaps months later doing this, right?
Absolutely, and that is, in fact, those are the considerations that the trial court discussed in the Hirsch case. And in fact, the trial court there deemed that the failure of the lawyer to disclose this impending reciprocal discipline, was akin to a misrepresentation to the court, because the court was trying to set a trial schedule, and just like here, there was no indication as to when discipline may be imposed. And there were multiple instances where Mr. Aranda could have disclosed it. He was suspended in May of 2015. There were 10 weeks that went by before the trial began. He could have disclosed it then. He submitted his paperwork to the First Department. He could have disclosed it then. The petition by the grievance committee to impose reciprocal discipline, where they make clear they're looking for an 18-month suspension, is filed and served on him 2 weeks before the verdict. He could have disclosed it then. He could have disclosed it at the time of the verdict. He could have disclosed it in any time in the 5 months that went on.
Thank you,
between
counsel.
there.
We understand the point.
Thank
You'll
you.
have your rebuttal time.
Thank
Counsel?
you.
Good afternoon, Your Honors. May it please the Court, my name is Sheila Bautista, and I represent the people in this case. Your Honors, defendant's Sixth Amendment rights were satisfied in this case when he received meaningful representation from his attorney. Based on his inability to demonstrate that he received ineffective assistance below, in the lower courts below, he is now claiming his attorney violated his rights under novel theories that would not require a showing of prejudice. But no legal or professional requirements With no legal or professional requirements to disclose the suspension, defendant...
Counsel, I'm on the screen. Why doesn't Rule 1.4 apply, right, that it's material? Don't you think it's material to know that the attorney's been suspended in another jurisdiction and, as a consequence, he is subject to reciprocal discipline? May not occur, but it might occur, and that would mean that the criminal proceedings are going to be thrown off course.
Your Honor, that rule doesn't impose a duty because suspension on its own pending suspension doesn't impact the ability of an attorney to represent the client. As was demonstrated here, this attorney provided...
No, but I understand your point. In fact, I don't disagree with that at all. That was where I started with with your adversary. The point is the potential for the discipline to occur during the trial. Doesn't that require some duty to the client, or at least to the court? I mean, the attorney is an officer of the court. Don't you have to tell the court, look, this might be coming? Look, if I'm on a trial, don't I have to tell the court, Your Honor, I've got surgery in 3 days that I cannot postpone. I have to do this surgery, so I'm not going to be available. I mean, we do that all the time. Why wouldn't you do this? Why wouldn't you disclose this?
Well, in this situation, there was no requirement for the disclosure. The Second Circuit order did not require it. The court's rules did not require it. So the defendant's claiming that his attorney violated...
But my point on this is, it's a little circular what you're saying. My point on this is, don't you have to disclose that because it may impact the criminal proceedings? You know that for a fact, that it may. You don't know that it will, but you know that it may, because the appellate division may indeed impose reciprocal discipline while the case is ongoing.
Respectfully, Your Honor, in this case, that's not necessarily certain, because the discipline that might be imposed in this case might not necessarily be a suspension. The rule is whether or not the attorney should be disciplined in the appellate division, but it's not a foregone conclusion that suspension would actually be the result.
Well, again, I don't think anyone is disagreeing with this point about we don't know what the appellate division would do. It might do something else. The point is, shouldn't the court at least, and perhaps the client, I understand these arguments are slightly different, be informed of something that may indeed have impact on the criminal proceedings to try and take some preventative measures?
Your Honor, it sounds like a reasonable requirement. But I have 3 reasons why this court should not create such a requirement or find such a requirement in this case. In this case would be an improper vehicle to create such a requirement. At the time of the trial, the defense attorney had no legal or professional duty to disclose. And so defendant's trying to show that his attorney violated his rights, but absent that duty, this defense attorney did not violate anything. Also on the record, defendant can't show that he actually would not have chosen this attorney. The record demonstrates that this defendant, he hired this attorney twice before and received favorable outcomes in those cases and received meaningful representation in this case. So based on that, number 1, this would be an improper vehicle for such a rule. Number 2, the proper vehicle for such a rule would be the court system, which promulgates the rules of professional conduct and attorney discipline. Such a new rule would raise a lot of questions, and these deliberative bodies could debate and discuss those questions, such as what should the scope of attorney disclosure be, what situations trigger disclosure, and should there be any limitations. As this court recognizes, the right to choice of counsel is a qualified right. These issues and these questions weren't properly raised in the 44010 court below, so they weren't properly explored by the judge. And number 3, another reason why such a rule isn't required in this case is because the defendant has existing protections. Interim suspension is available. It's an available form of relief if the attorney, based on a suspension in the foreign jurisdiction, if his conduct rises to the level that he really shouldn't be representing this client in state court, interim suspension is something that can be sought by the Attorney Grievance Committee. And of course, defendant can also seek relief under ineffective assistance of counsel claims. If his attorney is truly not able to represent the defendant below, he can show that there was an actual impact on the quality and the ability of his attorney to represent him at trial, which this attorney wasn't, which this defendant was not able to show.
And so do
below.
you argue that the ineffective assistance of counsel route is the better route if there was an actual impact on the ability to represent?
Yes, Your Honor, that's the proper course for this court to examine this issue, because the defendant is talking about something his attorney didn't do. He's talking about his attorney's conduct, and that is most properly assessed under ineffective assistance of counsel, where defendant has to show there was some detrimental impact to his attorney's ability to try this case or the quality of his representation, and he can't show either things under existing law. This defense attorney provided meaningful representation.
Suppose the appellate division had suspended Mr. Aranda right in the middle of the trial. How would you propose that would be handled?
Well, in that case, the rules require the attorney to inform his client. So in that case,
Well, at that point, he can't continue, can he? He's suspended from practice in New York.
Under the rules, the attorney would be required to tell his client that he's been suspended and advise his client to seek substitute counsel. In this case, he was still licensed when he represented his client. So we urge this court to find it under ineffective assistance. This attorney provided deficient performance. Provided effective performance. He was licensed to practice at the time that he represented the defendant in this case. As the appellate division found, the appellate division was the court that issued the suspension, and the appellate division ruled in this case that at the time of the trial, this attorney was still licensed to practice in New York. And as this court has been pointing out in some of its questions, at the time of the trial, nobody knew what exactly the suspension would be in this case. And finally, with respect to the right to choice of counsel claim, we argue that this would not be the proper vehicle for it based on the defendant's inability to show that his attorney violated anything in this case.
I'm not sure.
So counsel, if we disagreed with you on that point,
Yes.
that there was no ethical violation, does the defendant then get a new trial? Is he right?
Well, he would
Counsel,
still have to show that he actually would not have chosen this attorney. And on this record, on the existing record, he can't show that. This is
Well, how, other than saying, if I knew that, I would certainly have never gone forward with this individual, given the nature of what the Second Circuit concluded, what else could he possibly have said?
He made
What else
that,
could he do?
he made that claim, but it was undermined by the longstanding relationship he had with this same attorney. This same attorney represented him twice before and received favorable outcomes for this same defendant.
So you mean it's one rule if it's an attorney that just got assigned to me, I don't know anything about them, and then there's this pending discipline versus someone who I've had for a long time and, perhaps my trust has been betrayed because they've been not complying with the professional standards.
These are just the facts of the case. The facts of this,
I know they're the facts of the
Right.
case. My question is how it impacts on the legal conclusions we're asked to decide here, to resolve the issue before us.
these facts show that this particular defendant his rights to choice were not violated. The attorney that he chose was an attorney who had performed well for him before and performed well for him in this case.
Yes,
So-
I understand, but one would assume that a client would not choose an attorney who they thought was deficient. One would choose an attorney who you thought is going to represent me well, especially if they had a track record in the past. But this is not about his past. It's about the lawyer's past.
Let me try Judge Rivera's question a little bit differently. Suppose he could prove, to your satisfaction, that he would not have continued with Mr. Aranda had that been disclosed. Has he then been denied his constitutional right to counsel? And if not, why not?
Well, in this case.
No, suppose he could prove that, hypothetically. Forget him
Okay,
for a moment.
okay.
Suppose a defendant could prove, if I had known that this lawyer was suspended, I never would have continued with him. Suppose you take that as a given. I know that's not this case. Take that as a given. In that circumstance, has that person been denied his constitutional right to choose counsel?
Without a legal or professional requirement for the attorney to make the disclosure, no. He has not shown it, because he has to show two things. He has to show that his attorney violated something. He'd have to show that his attorney violated a legal or professional duty, one. And two, he'd have to show that he actually would not have chosen this attorney. This defendant can't show either of those things. So he would not prevail on his right to choice of counsel claim in this case.
Thank you, counsel.
Thank you.
Counsel, your rebuttal?
Yes, and getting back to the court's inquiry that was just posed to my adversary, on page 408 of the record, the facts are crystal clear that Mr. Burgos would not have allowed Mr. Aranda to continue as his attorney had he known about it. What he says is, in his affidavit, had I known what I know now, referring to the suspension, I would not have agreed to have my case tried by the court without a jury. I would also not have permitted Mr. Aranda to remain as my attorney.
So your argument is his word alone is sufficient to establish that he would have chosen a new attorney?
Yes, that is the only evidence that's before the court. That's the only evidence that would be pertinent to that issue. And getting back to Judge Rivera's question posed earlier, her statement earlier, that we don't know about what the appellate division would have done. That applies in an instance where there has been counsel removed. There's a choice of counsel sort of proceeding that's occurred, and at the time of the removal of the attorney, the trial court doesn't know what's going to happen. That's not this case. We know exactly what the appellate division would have done because they did it. They suspended Mr. Aranda. They made that suspension retroactive to a date that preceded appellant's trial, that flowed throughout the trial, throughout his sentencing, throughout the verdict. He did not have counsel within the meaning of the Constitution based upon that.
Thank you, counsel.
Thank you, Your Honors.